Hello, everybody. The Court of Justice has issued a press release on the 17th of December 2020 about a verdict it has put out against the member state of Hungary, which will undermine the border security for the entire European Union. This is the case C808/18, and I will run you through the document Tim Pool-like because it's only four pages long, and I think it's worthwhile discussing the background as I'm reading along. The headline is: Hungary has failed to fulfill its obligations under EU law in the area of procedures for granting international protection and returning illegally staying third country nationals. In particular, restricting access to the international protection procedure, unlawfully detaining applicants for that protection in transit zones, and moving illegally staying third country nationals to a border area without observing the guarantees surrounding a return procedure constitute infringements of EU law. Maybe I should already start explaining here that there was no detention whatsoever. The transit area is actually open to Serbia. It's just that they don't allow people to go into the country any further than that transit area, and that procedures like the application to the asylum process are to be taken within that area, and they have actually not moved people into that area as far as I can tell. The Court of Justice has already gone so far. This is just the last instance of a number of cases that they have successfully shut down that entire transit area for a couple of months now, and Hungary has proceeded in moving asylum seekers to different application centers. I'm not quite sure how they are handling it now, but the court has basically already shut down a large portion of the Hungary border control, and if they continue, they will destroy the entire defense Europe has against unlawful immigrants. In response to the migration crisis and to the ensuing arrival of large numbers of applicants for international protection, that is asylum, Hungary adapted its legislation on the right to asylum and a return of illegally staying third country nationals. Thus, a law of 2015 provided, inter alia, that's among other things, for the creation of transit zones situated at the Serbian-Hungarian border, in which asylum procedures are applied. That law also introduced the concept of a crisis situation caused by mass immigration, leading, where such a situation is declared by the government, to the application of derogatory rules in the guise of general rules. In 2017, a new law expanded the cases in which such a crisis situation could be declared and amended provisions allowing derogation from the general provisions. In 2015, the European Commission had already expressed its doubts to Hungary as to the compatibility of its asylum legislation with EU law. And it is indeed the Commission that has been behind all these court cases on the Court of Justice. So it is really coming top down. What we see here is that there have been a number of treaties in the past that enshrine an equalization of the laws of the various countries, also with regards to asylum. There is now a convergence of the legislation going on that is actively being put forward. It's not just the ever closer union that is a part of the foundational documents they call foundational treaties, but they are de facto, they are constitutions. So in our constitution, so to say, there is already decided that the union is to become ever closer, and it is in these constitutional documents that it is already decided that our laws are to be equalized over the diverse countries, and that the people should actually have no say by what laws they are to live, which is the definition of a democracy. If you just remember, demos being the people and kratia being the rule, and democracy whatever way you want to look at it, is supposed to be the system with which we give ourselves our laws. So this is to be watered down in favor of an equalization of the rules across the entire continent, without any accountability to the people that supposedly give themselves the rules. And the problem is that politicians from countries remote from the border have an easy time to dodge the questions from the citizens that the legal system is, very easy on every applicant. So everybody has like 20 trials before he or she gets deported. It is very lenient, and that could be sold to the public for a long time because there were just few cases, right? But in Greece, in Italy, in Spain, a lot of people come, and they have to have different rules to get rid of all of these for applicants. And if you equalize these rules, and you have to explain to the Irish, the Germans, the Swedish, and so forth, why they have to do these inhumane things like sending somebody back to the country where they came from. And many people are not used to the debate, and they can only see the individual pictures on TV of weepy cases where somebody is the nicest person on the planet and has to go home. So their rules, their standards are being rolled out to places that have a lot applicants that have to deal with that, and have for that reason stricter rules and faster processes, or who need at least stricter rules and faster processes. The text continues with the 2017 law raised additional concerns. It criticizes Hungary in particular. Here it means the EU. The EU Commission. The EU Commission criticizes Hungary in particular for having a disregard of the substantive and procedural safeguards provided for in the procedures, reception and return directives, restricted access to the international protection procedures, established a system of systematic detention of applicants for that protection and forcibly applicants for asylum, and forcibly deported to a strip of land at the border, illegally staying third country nationals without observing the guarantees provided for in the return directive. As I said, this return directive is dominated, or was the design of which is dominated by countries that are remote from the border and who don't know the matters. The people don't vote on such matters because they had in the past not so many encounters with refugees. Now that's of course changing a bit, but it shows the overall problem with globalization and multilateralism. One size fits all does fit nobody. In that context, it brought an action for failure to fulfill obligations before the court, seeking a declaration that a substantial part of the Hungarian legislation in the area infringes certain provisions of those directives. I must also say that a directive does not admit to be a law, but in effect, as you see, there's an entire court and everything. It is basically a law. They expect it to become a law. And this is the basic dishonesty of our globalists or multilateralists or anywheres, or however you want to call these people. They usually pretend that the European Union were not a nation, but it has an anthem, it has a flag, it has a court, it has a parliament, it's churning out ever more rules, and they just expect that this stuff is ratified by the national governments and becomes your everyday law. So in effect, they are churning out the laws, but they are not admitting it. So unofficially, they are just some countries that come together, kumbaya, just sit informally, haggle out some deals and some guidelines. That's how they sometimes refer to the directives. So it's all informal and happy and non-binding, as long as the cameras roll. But then they actually do expect everything to be ratified. And we've come to that place where ratification has become an automatism, extremism, and our leaders do no longer try to negotiate and publicly debate and put out ideas to govern the countries under them. Instead, they rather join up with their fellow colleagues from different countries. Then they decide on a paper, a treaty, and then they come back to their people and expect from their parliaments and from everybody else that their ideas are being pushed down our throats. That is globalism. A lot of people say globalism, that's maybe the Jews, or maybe that's the banks, or whatever. No. Globalism, that's a real thing. That's people who go to summits, who go to conferences, and who just expect that whatever laws they wish for their countries and whatever expenditures they wish to pay with taxpayers' money, that they just agree on that with their colleagues from different countries, and then they come back and expect everybody to subdue, to just simply push that through automatically, ratify it as an automated process, and then cram it down your throat. As a preliminary point, the court notes that it has already settled some of the issues raised by the action in a recent judgment delivered in the context of a reference for a preliminary ruling made by a Hungarian court. It also notes that in order to comply with that judgment, Hungary has since closed its 2 transit zones. The court emphasizes, however, that closure has no bearing on the present action, the situation falling to be assessed at the date laid down by the Commission in its recent opinion for addressing shortcomings, namely the 8th February 2018. In the first place, the court holds that Hungary has failed to fulfill its obligation to ensure effective access to the procedure for granting international protection. If you have seen the treaties, they have actually agreed that every country has an obligation to help refugees to start a legal process. I have a tremendous problem with the fact that an international body forces a democratically elected government to allow strangers, perfect outsiders who are not citizens, to start legal processes in their countries. And the legal protection that amounts to non-citizens, and in this case the refugees or applicants for international protection, they amount to a clogging of the entire judicial process. It is not feasible for either Hungary or any other country to allow millions of applications to clog the legal system. There are so many people all around the world, in Africa, Asia, Latin America, who want a better life, who want to apply for a stay in the Western world, and they can't all have it. It is impossible to do, and yet these international treaties, they demand it. These backdoor deals, until they really ripple down to your average citizen's life, that takes for years, and we are now seeing the consequences of these contracts dating back to 2002 or 4, a very long time back. Where it's already getting crazy, where they actually demand that individual countries shall take all applications, and that they should even help outsiders, non-citizens, to start legal processes. This does not quite square well with the amount of people that are expected or reasonably expected to come. For the sake of having an entire sentence, I have to start it again. In the first place, the court holds that Hungary has failed to fulfill its obligation to ensure effective access to the procedure for granting international protection, insofar as third country nationals wishing to access from the Serbian-Hungarian border that procedure were in practice confronted with the virtual impossibility of making their application. That failure stems from a combination of the national legislation, according to which applications for international protection may, as a general rule, be made only in one of the 2 transit zones, and a consistent and generalized administrative process established by the Hungarian authorities consisted in drastically limiting the number of applicants authorized to enter those zones each day. For the court, the existence of that practice has been sufficiently demonstrated by the Commission, which relied on a number of international reports. So there's actually no proof, right? So they have already judged that there is no proof that the NGOs, I suppose, were right that applications could only be taken in one place but not in the other. And quite frankly, there are so many NGO types running around in these places that you could imagine every one of them could actually play the postman. So there was no virtual wall between an applicant and starting the legal process, I assume. In that context, the court recalls that the making of an application for international protection prior to its registration, lodging and examination is an essential step in the procedure for granting that protection, and that member states cannot delay it unjustifiably. On the contrary, member states must ensure that the persons concerned are able to make an application, including at the borders, as soon as they declare their wish of doing so. In the second place, the court confirms, as it has recently held, that the obligation on applicants for international protection to remain in one of the transit zones for the duration of the procedure for examination of their application constitutes detention within the meaning of the reception directive. Well, there are two things. First, they all can go. That thing is not a detention. A detention is when you cannot go, and they all can go. They can all go back. And the second problem is that if people are already coming from places that are perfectly safe, like Serbia in this case, why would you take applications to begin with? Okay, why them? Why not ask people in India? Why not ask people in Africa if they are safe or if they need protection? Why should you ask people who've just come from Serbia, which is a perfectly safe place, whether they need a special protection? There's absolutely no reason why these people should be prioritized over everybody else. Only because they have already moved so far does not mean that they have a special right or that they have a special grievance compared to anybody else. The text continues with that matter having been clarified, the court finds that this system of detention was established outside the cases set out in EU law and without observance of guarantees which must normally govern it. After all, first, the court recalls that the situation in which the detention of an applicant for international protection is authorized are listed exhaustively in the reception directive. After analyzing each of those situations, however, it concludes that the Hungarian system is not covered by any of them. Yes, because you can only detain somebody after you have already closed the case and you say he is not, his application is not valid and he must be deported, right? You can only put somebody in custody if you plan to deport the person. If you don't know yet, and you know, for all these legalese, these people are seen as potential applicants. So you cannot just lock them up and wait for the deportation. You have to leave them in that transit zone. However, the transit zone is not a detention. The court examines in particular the situation in which a member state may detain an applicant for international protection in order to rule on his or her right of entry into its territory, that detention being able to take place in the context of procedures applied at the border with a view to verifying before granting a right of entry whether the application is not inadmissible or whether it is unfounded for certain specific reasons. The court considers, however, that the conditions in which detention is authorized in the context of the border procedures are not fulfilled in this case. Second, the court emphasizes that the procedures and reception directives require, inter alia, that detention be ordered in writing with reasons, that the specific needs of applicants identified as vulnerable and in need of special procedural guarantees be taken into account in order that they receive adequate support, and that minors be placed in detention only as last resort. We also have the claim that basically everybody who makes it across the border is a minor. You have very old-looking minors here since 2015. In any event, it's not a detention. Owing in particular to its systematic and automatic nature, however, the detention regime provided for under the Hungarian legislation in the transit zones concerns all applicants other than unaccompanied minors under 14 years of age, does not allow applicants to enjoy those guarantees. Moreover, the court rejects Hungary's argument that the migration crisis justifies derogating from certain rules in the procedures and reception directives with a view to maintaining public order and preserving internal security in accordance with Article 27 of the TF, some treaty EU. In that regard, it recalls that the article must be interpreted strictly and considers that Hungary does not demonstrate sufficiently its necessity of having had recourse to it. In addition, the court points out that the procedures and reception directive also account the situation where a member state must face a very significant increase in the number of applications for that's asylum, since they provide for specific provisions for the possibility of departing from some of the rules imposed in normal times. Well, you know, these treaties, they have also created a fund and everything, and they believe that throwing some money into that this or that corner, usually to just simply shut people up, were sufficient. Now, it does not stop people from coming, and you have you have millions and millions of people who actually would like to come. You have to kind of create a perspective where these people have a good life in their own countries, which is birth control, which is limits to the government there, so a fight against the tyranny, provision of information of how it's done, you know, living by example, granting freedom of speech everywhere, for example, on the internet, so that the Russians don't have a cheap excuse, for example, to shut things down, and the Syrians don't have a cheap excuse to shut the internet down. So, you know, living by example and so on. There are like a million pathways that you can actually go to improve the lives of all these people all around the world, so that in the next generation or the following generation, people would have a better life and would not even wish to come, okay? But none of these roads are being taken. Rather to the opposite, we have a socialist, an outspoken socialist at the head of the United Nations, for example. We have an elite that is determined on destroying the industry and the economy worldwide, just to be safe on top of the echelons in their respective societies. And these elites who recklessly destroy everything have absolutely no reason to stabilize their countries. They are happy to see everybody move around and to destroy the neighborhoods everywhere, and not to solve any single of these problems. The text continues with, in the third place, the court holds that Hungary has failed to fulfill its obligations under the Return Directive insofar as the Hungarian legislation allows for the removal of third country nationals who are staying illegally in the territory without prior compliance with the procedures and safeguards provided for in that directive. As I said, this endless abilities to go from one court circuit to the next. And on that point, the court knows that those nationals are forcibly escorted by the police from the other side of a fence erected a few meters from the border with Serbia to a strip of land devoid of any infrastructure. According to the court, such forced deportation is equivalent to removal within the meaning of the Return Directive. The persons concerned in practice have no choice other than leaving Hungarian territory. Yeah. And going to Serbia, which is a perfectly safe place. In that context, the court recalls that an illegally staying third country national falling within the scope of the Return Directive must be the subject of a return procedure in compliance with the substantive and procedural safeguards established by that directive before his or her removal, where appropriate, is carried out, it being understood that forced removal is to take place only as a last resort. Furthermore, for reasons similar to those set out above, the court rejects Hungary's line of argument according to which it was allowed pursuant to Article 72 of TFEU to derogate from the substantive and procedural safeguards established by the Return Directive. In the fourth place, the court considers that Hungary, there are no details for why they reject this, strange enough. In the fourth place, the court considers that Hungary has not respected the right conferred in principle by the Procedures Directive or on any applicant for international protection to remain in the territory of the member state concerned after the rejection of his or her application until the time limit within which to bring an appeal against that rejection, or if an appeal has been brought until a decision has been taken on it. After all, the court notes that when a crisis situation caused by mass immigration has been declared, the Hungarian legislation makes the exercise of that right subject to detailed rules not in conformity with EU law, in particular the obligation to remain in the transit zones, which resembles detention, contrary to the Procedures and Reception Directives. Here again we are talking about EU law, and you've seen that a lot. There are entire studies on universities now offered called international law, which is basically reading treaties between the nations. So there is actually no law. There can't be a law, because in a democracy it is a people that has a process like the public debates, the elections and so forth. In a democracy, people have the process in their hands with which they give themselves their laws, their rules. These bureaucrats, like the globalists, anywheres, these people believe that when they sit together in some summits and some conferences and decide for all of us, this were law, and they are calling this law. If they call their own ideas, their own rules, laws, then that means that they have also created a nation. But yet that step is also something they would not admit, because they are deep down to the marrow of their bones dishonest people. The text continues with, on the other hand, when such a situation has not been declared, the exercise of that right is made subject to conditions which, while not necessarily contrary to EU law, are not defined in a sufficiently clear and precise manner to enable the person concerned to ascertain the exact extent of their right and the compatibility of those conditions with the Procedures and Reception Directive to be assessed. Note: an action for failure to fulfill obligations directed against the member state which has failed to comply with its obligations under European Union law may be brought by the Commission or by another member state. In this case, it was the Commission, obviously. If the Court of Justice finds that there has been a failure to fulfill obligations, the member state concerned must comply with the court's judgment without delay. Here again, we are seeing the pretense that this is not a nation, in combination to, if we don't automatically ratify what we've declared without any binding in our press conferences during our summits, when we just had some little chat about this and that, if we don't apply everything that comes down to you, then you are transgressing, and that may have future implications on whether you may remain a member, or if you are just deprived of funds from the community funds and so forth. Where the Commission considers that the member state has not complied with the judgment, it may bring a further action seeking financial penalties, just as mentioned. However, measures transposing a directive have not been notified to the Commission. The Court of Justice can, on a proposal from the Commission, impose penalties at the stage of the initial judgment. Yeah. And of course, this is not the full text. This is a media press release, but I think it gives you enough insight for now, and I hope to see you soon. Bye.